If you're a defendant, if you hear that, you're going to jail. If you're an attorney and you want to go to that next level, you need us, right? Next level success requires next level thinking. I got you. I just want to be real clear what the value proposition is here at Monarch and Moreau. We help you increase your bargaining power at the point of sale, at the bargaining table. I want to talk to you a little bit about Monarch and Moreau for attorneys. What can they do to win? I'm going to show you. Attorneys, they're very good advocates, right? They don't always structure their arguments or know how to structure their arguments outside of maybe like their base mental models. The next level thinking is required for that next level success.
Do you smell what the Rock is cooking?
Your criminal attorney is most likely overworked, got a lot of cases, might be a public defender. I think Peter Thiel said that if you're a single-digit millionaire in America, you can't afford to defend yourself in court. You can't get the legal representation that you need. So you've got a case and you need to create one of these, okay? There's two types of factual scenarios now. So we've got the first factual scenario, and that's the one that the government is trying to prove. It's called the inculpatory factual scenario. Number one, inculpatory. And this is the one that they're going to spend all their time showing the jury. So you're a defendant and you're charged. Your defense attorney is going to tell you that you don't have the burden of proof. The government has the burden of proof. All we got to do is we got to, cast doubt. If you're a criminal defendant, I'm going to tell you right now, if your attorney says that we don't have to prove anything, we're going to draw doubt on their case. If you hear that, you're going to jail if your attorney tells you that.
Do you smell what the Rock is cooking?
Or if you're a trial attorney, the reason you're saying that is because you don't have skills, right? That's the easiest thing to do, but it's also the thing that's guaranteed to kill your defendant, right?
Do you smell what the Rock is cooking?
Because the standard is beyond a reasonable doubt. So our strategy, defendant, is going to be to cast doubt on the case. So there's another factual scenario, however, right? So we've got this thing over here called doubt, okay? Then we've got this other factual scenario. It's called an exculpatory factual scenario. And I'm going to try to keep it to the base premise. We're not going to go all into decision making, but I could. If you wanted to, we could go into that. How do people make decisions? I could go ahead and educate you up on that. But if the government has presented a coherent, inculpatory factual scenario, and all you want to do is try to cast doubt on that, you're dead. But that's part of the burden of proof. Do you understand what I'm saying right there? If you're a criminal defendant and you're guilty, the system is set up to cater to you. If you play ball, if you tap out, they're willing to go easy because you're going to save them some trouble. But in order to uphold that, we're going to save you some trouble. If you make this easy on us, we got to make it hard on you if you go to trial, right? So the stakes are high. You need to be able to articulate and bring to life from the facts an exculpatory factual scenario, an alternative scenario where your client is innocent. But that's part of the burden of proof. Do you understand what I'm saying right there? If you can't do that, and most of you can't, which explains the Bernie Madoff-like conviction records, right? Do you understand what I'm saying right there? So I'm going to write some well-known proof concepts up here on the board. We're going to have a short discussion about it just to set some foundation. And we're talking about the court of law, criminal justice system. That's the ultimate rubber meets the road. You got to have power at that table, right? We've been talking about rhetoric, so we're going to talk about it in law, right? Because we think rhetoric should apply there, should apply to the law. But we got to get the basics out, right? So write this stuff up on the board. We'll talk about it, all right? First one, beyond doubt, right? Highest burden of proof, beyond a reasonable doubt. Then we got clear and convincing. Then we've got preponderance. Then I'm going to go one more. I'm going to go to substantial. Highest level, clear and convincing. So if it's clear and convincing you've been abusing your children, state can take them. But if it's clear and convincing he committed the crime, then he must be acquitted. Preponderance is civil case. It's more likely than not that that company was the but-for causation for all these cancer cases, right? Then you've got substantial evidence, which is kind of like the bare minimum. So when you hear substantial evidence, you might think, oh, they got a lot of evidence. It's basically enough evidence to establish a prima facie case. We won't get into all that. Now, so you got these up here, and in a criminal trial, defense attorneys, you're going to tell the defendant that they've got to prove their case beyond a reasonable doubt, and you, defendant, you don't got to prove anything, okay? If you're a criminal defendant, I'm going to tell you right now, if your attorney says that we don't have to prove anything, we're going to draw doubt on their case because all we have to do is we have to get it below that and you're good. We're going to draw doubt on the if you hear that, or if you're a trial attorney, you're going to jail if your attorney tells you that.
Do you smell what the rock is cooking?
Let's just be real. So I'm going to wipe this down, and then I'm going to come back with what actually has to happen in this scenario. Okay, so in this scenario, right, the government is going to present their case. This is what we're going to substitute the word case for something else. This is number one. It's called an inculpatory factual scenario. Inculpatory factual scenario. That means it implicates, it inculps with guilt your defendant. The facts lined up and presented in a persuasive manner, right? They produce it. Now their next burden is persuasion. So they're going to attempt to create a coherent story, a narrative, an inculpatory factual scenario that leads to only one conclusion, the guilt of your defendant. And you're telling your defendant, 99 out of 100, we're going to poke holes in that and draw doubt to it. Okay, how are you going to do that? The only way you're going to do that is if you spend the time and you have the skills to articulate and bring to life in vivid detail number two. And what would number two be? It would be an exculpatory factual scenario. What? Convince the defendant that the defendant should plead guilty, right? Then that's a different bargaining table. We could get into that. But if we're going to convince the defendant to plea, we're going to be able to negotiate a much better plea deal if our banta is much better, right? What's our banta? Our banta is our best alternative to a negotiated agreement. That would be a trial. A couple, thoughts on best alternative to a negotiated agreement. That's going to be testing the government's case versus your exculpatory factual scenario. What do you got that supports that, right? Now, when it comes to presenting this in court, we've got two burdens there, right? The first one is production. And number two is persuasion. This is where we help you at Monarch and Moreau. I'll get into that. Production would be like our case turns on whether or not, in some extent, there's a stick in the woods or not. So we got a stick in the woods, and we're going to present photographic evidence that that stick was there when we said it was there in those woods on that day. And we've got people to testify that it was, verify, validate the photographic evidence. So if that's a material issue, we could check that off. Stick in the woods. Now, we're going to be able to produce all that. That's our production of evidence. Which direction does this stick in the woods point? That's persuasion, right? Because a stick in the wood points in two directions. So we're going to argue about that. That's persuasion. So we've got our burdens of proof for the jury, and then we've got our burdens of presentation in court. Production and persuasion. Now,
do you smell what the rock is cooking?
It's a narrative, right? You have to command the facts to control the narrative. And frankly, no matter how good of advocates attorneys claim to be, if they can't do that every time. Okay, lawyers, let me time you out real quick and walk you through the role commitment. Why do I say that? Because I know there's a lawyer out there and they're thinking to themselves, listen, I got a higher obligation to the court that the truth comes out, not this, that I win for the defendant, right? So I want you to put that on hold for a minute. I want you to think about the fact that that's not really what's going on in a criminal trial. The standards are higher, right? So I don't know where that came from, but the burden of proof is beyond a reasonable doubt. It's not the burden of truth. Truth as you see it. So developing an exculpatory factual scenario to test the government's case, that's representation, right? That's real advocacy. Now, you say I need to win on the facts. I'm going to show you how you can have complete confidence that you're going to win on the facts. Now, defendants, time out. I want you to ask your attorneys right now, put this on pause. Say, criminal defense attorney, when you say we're going to win on the facts, what do you mean by that? You just listen to what they say. Attorneys, this is what you're going to say, because this is the truth. A fact is nothing more than an observed normality. A fact is an observed normality. Right? Very normal, find a stick in the woods. There's plenty of them, right? I'm sure the government can find plenty of sticks in the world that can find plenty of dead bodies and call them murder victims, right? That's normal. Those are facts. You want to win on the facts, it's something else, right? Because which way that stick points, whether it points in your direction, that's a matter of persuasion. That's a matter of argument. So winning on the facts is a little bit more than just observing the facts, right? That's why we got to do more than poke holes. If we're going to test the government's case, we have to test it against an equally persuasive, exculpatory, factual scenario.
Do you smell what the rock is cooking?
So we're not proving guilty defendants innocent. What we're doing is we're demonstrating that the strength of the government's case can't withstand a plausible, exculpatory, factual scenario. Meaning that it's not about truth, it's the fact that the government's case was tested and it couldn't overcome any reasonable doubt. That's how you win on the facts. It's not, I'm not going to do this because my client's guilty. I don't want to prove guilt, as innocence. That's the wrong way to think about it. What you're demonstrating is the strength of the government's case isn't strong enough to withstand that burden of proof, as demonstrated by your very plausible, well thought out, well crafted, well articulated, powerfully persuasive, exculpatory, factual scenario.
Do you smell what the rock is cooking?
If you don't have one, or your attorney doesn't have one, they're going to lack power at the point of negotiation, because this is your banta. This is your best alternative to a negotiated agreement. How isn't it, right? And when you spend no time developing this, you only spend time on your talk track of how am I going to get this guy to plead guilty? He needs to plead guilty. So you're doing that while you're having the negotiations, right? Part of the reason why there's so many ineffective assistance of counsel cases being, leveraged against you. Now, defendants, here's what you need to know.
Do you smell what the rock is cooking?
You need to ask your trial attorney before you go to trial, what's our exculpatory factual scenario that paints the pictures in a powerful and persuasive way that leads to only one conclusion, my innocence. That's what they have to develop. Now, if they can't do that, if you don't know how to write that narrative, then ask for help. I can teach you. That's why I'm here. But I've got this sneaky suspicion that a lot of you don't want to strengthen the resolve of your clients going to trial. Maybe it's because you're worried they'll lose. Maybe because that's just not how the game's set up. But if you are, I'm here. I'm here for you when you need me, right? Because we'll put together an exculpatory factual scenario that you can't poke holes in it, right? And defendants, you're going to encourage your attorneys to hire us for the case, right? They need us. Just like you need an investigator, you need a forensic document specialist, you need all kinds of reports, toxicology, you need Monarch and Moreau, right? Because this is just like basics to us, right? But to most trial attorneys, this right here, this would be next level. And admit it, this would be next level. So we can do this for you, or we could teach you how to do this every single time.
Do you smell what the rock is cooking?
But if you don't have this and you go to trial, you're dead. It's over with. You're dead. It's not going to happen. You're dead. Okay? You're not going to poke holes in it, because they're going to lay out both proof and persuasion of why you're guilty. You're not poking holes in that, and you're not negotiating anything without an exculpatory factual scenario. You tell me what you want to do if your life's on the line. Okay, so here's the take-home message for defense attorneys. You're going to ask yourself, before plea negotiations, you're going to say, what is my exculpatory factual scenario? What is it? Beginning, middle, end. What is it? What supports that? And defendants, before you make any deals at all, you're going to say to your lawyer, you're going to ask him to tell you, or ask her, you're going to say, Miss Lawyer, Mr. Lawyer, please tell me from beginning to end what your exculpatory factual scenario is for me. Those are the questions you need to ask. And when you've got answers for those, you're in a position to make a well-informed decision. But if you don't have that, how are you going to make a decision of what you should do? You're not even attempting to measure the strength of cases, right? So we need to develop the exculpatory factual scenario before we do anything else. If we can't, right, that's information of another kind too. So something to think about. Most likely your defense attorney hasn't done that, right? Because that takes work. But that's where your banta comes from. If you don't have that, you're not going to be persuasive at the bargaining table. How are you going to be persuasive for your clients at the point of sale at the bargaining table if you haven't developed that banta, that exculpatory factual scenario? So all these plea discussions happen early, and then it's like the preparation for trial happens. But Peter Thiel says that if you are a single-digit millionaire, you can't even afford to defend yourself, put on a good defense for your life in America anymore. Because the representation, the advocacy that actually shows up in court, we won't get into all that, but you have to be able to ask yourself, beginning, middle, and end, what's my banta, what's my exculpatory factual scenario, right? That's just not being developed. And then the skills to bring it out at the point of sale, right? Can you really talk to the prosecutor without revealing too much? Is your fear, I don't want to give away my defense, right? That's lame. Right? You know what I mean? We got to have the words. We got to be persuasive. We got to be confident in them. So if those things haven't been developed, if we haven't, developed that factual exculpatory scenario, I don't see how it is that we're going to the bargaining table and we're doing our good job, right? We're not. We're not doing our best job. We're not.
Do you smell what the rock is cooking?
Do you want to do your best job? Do you want to have the best words, the best arguments? That's why you mess with Monarch and Moreau. But you're not doing the best job right now. The prosecution is killing you. I just want to be real clear what the value proposition is here at Monarch and Moreau. We help you increase your bargaining power at the point of sale, at the bargaining table.